On Wednesday, the Supreme Court upheld the state of Tennessee's ban on trans minors' gender-affirming medical care in a 6-3 decision written by Chief Justice John Roberts. Here to walk us through what this means is Joshua Block, a senior counsel with the National ACLU's LGBTQ and HIV projects, and someone who is no stranger to arguing before SCOTUS. Josh, thanks so much for joining us.
Thanks for having me. Happy to be here.
So, before we get into the court's decision, can you briefly explain what was before the court in this case, U.S. v. Scarametti?
Sure. What was before the court was the constitutionality of a law in Tennessee that's similar to laws that, swept the country in the past couple of years. Before 2001, no state had a law prohibiting gender-affirming medical care for minors. Arkansas was the first one. Everyone was horrified by it. The Republican governor vetoed it. But in the course of just 2 to 3 years, basically cookie cutter bills, were passed by GOP-controlled legislature after GOP-controlled legislature, often with supermajorities that could overcome gubernatorial vetoes. These laws banned medical providers from providing care that would be inconsistent with a minor's biological sex, is the term used, or sex designated at birth, but the specific phrase was inconsistent with their sex. And these laws were, on their face, designed to prevent people under 18 from getting a gender-affirming medical care, even though all the professional medical organizations in the United States have, long supported this care as being medically necessary. And even in countries that have sort of tightened protocols for the care, no country has ever banned it the way that these laws were doing. I mean, at least none of the European countries that had recently restricted care. This is a complete and categorical ban. These laws are really devastating for the families of trans kids in Tennessee and elsewhere. I mean, these are kids who have received these medications to allow them to live as who they are. Lots of kids, from an early age have, the trans boys who have always lived as boys from like a very early age, trans girls who have always lived as girls. These laws would forcibly detransition them. And it's no surprise that, families have done everything they could to challenge these laws, to get care out of state or to relocate their families if they need to. We've had basically refugees.
It's unbelievable. Okay, so this case winds its way or wends its way up through the court system, ends up at the Supreme Court, and a 6-3 majority, that's Chief Justice Roberts, joined by Thomas Alito, Gorsuch, Kavanaugh, and Barrett, says that a state can, in fact, ban this medical care. And tell me if I have the reasoning correct, because in Tennessee's case, the law doesn't single out trans people in the sense that it prevents doctors from prescribing these so-called puberty blockers to all minors, trans or cis, to treat gender dysphoria. Is that right? So that even though the law was clearly written with trans people in mind and will affect trans people overwhelmingly, the people who crafted this law were very careful maybe to make it apply to all minors for like just this reason?
I know. I don't think they were very careful. The thing is, these medications are given to cisgender minors to treat all sorts of medical conditions. They just can't be given to trans minors for the purpose of treating gender dysphoria. So if you're a cis woman who has a medical condition that causes excess hair growth, like facial hair growth, you can get the same hormones to stop that excess hair growth. But if you're a trans woman who has hair growth as a result of their sex designated at birth, you can't get the same medication. Same thing with puberty delaying medication. So the idea that this applies equally to trans people and cis people is like saying a ban on same-sex marriage applies equally to straight people and gay people, that no one, whether they're gay or straight, can marry someone of the same sex. And that is actually an argument that was made to oppose the legality of marriage for same-sex couples. And of course, everyone, including the Supreme Court, recognized that was bullshit, right? And so, but they're accepting precisely the same argument here when used against trans kids. The idea that everyone is prohibited from gender transition is ridiculous because the only people that need gender transition care are trans folks.
Yeah, well, that's what I'm getting at is that Robert's logic here seems to, and the logic of the majority is basically saying that this law on its face does not discriminate against trans people. Am I correct? And
It,
that's what
it
they are saying?
that is what they are saying, and I think that the fact that it seems like a confusing way to paraphrase is because it's such a tortured
Yeah.
reasoning. But and again, the same thing now is used not just against marriage for same-sex couples, but also marriage between interracial couples. They said everyone, no matter their race, is prohibited from marrying someone of a different race. And what's really critical here, though, is that Justice Sotomayor takes them to task on this and says that this is exactly the same bullshit reasoning that have been rejected in all these other contexts. And the court in Roberts, what's really critical is he actually agrees with her that in all those other contexts, this type of reasoning wouldn't work. And he says, but we're going to accept this reasoning here in the specific context of medical treatments. So he's basically carving out a medical treatment exception
Yeah.
to common sense.
Right.
And it's super frustrating because it's sort of a because I said so response, but at the same time, it's important to recognize that he does acknowledge that for other things, like taking a job inconsistent with your sex at birth, taking wearing clothing inconsistent with your sex designated at birth, he agrees that that would be trans discrimination. He's just saying for medical treatments, we're going to have this, special arbitrary rule.
So explain something to me. What is there's a phrase that's being used a lot in this decision and in talking about this decision, and that it's a phrase called heightened scrutiny. Can you explain what that is and why it's so important here?
So scrutiny, of course, means looking closer at something. And so most laws, like economic regulations, just get a very deferential review by the court. It's called rational basis review. And the law is presumed constitutional. And the court doesn't actually look at the underlying evidence supporting the law. The court just says, oh, could someone rationally think that this law makes sense, even without looking at the evidence to see what the facts actually show. All that matters is, could someone rationally sort of guess that this might make sense? And that's rational basis review. There are some laws, though, that get heightened scrutiny. The court looks closer at them. And for those laws, the court presumes they're unconstitutional, and the government has to come forward with actual evidence supporting it. So they can't just say, we think this, they have to prove it. And so this sort of heightened scrutiny for laws began with laws discriminating on the basis of race. So if you're going to discriminate on the basis of race, it's presumed unconstitutional. They have to prove why it's absolutely necessary to do that. But that a heightened scrutiny also applies to laws discriminating on the basis of sex. So if you're going to have some generalization about, men and women being different or having different desires or skills, they need to actually prove it. They can't just base it on assumptions or, old, habits of thinking. And so in this case, what's really important is every single court that has actually looked at the evidence under heightened scrutiny that said, okay, let's have some expert testimony. Let's look at what are they saying about this care, and is that actually true? Every single court to apply heightened scrutiny has said that these laws are unconstitutional. The only courts that have said this law is constitutional are ones that are doing so by applying rational basis review and not looking at the evidence. So if the evidence for banning this care was so strong, then they should be able to survive heightened scrutiny, but they can't. They can't pass the heightened scrutiny test. And so the Supreme Court and then some other courts that have upheld laws like this are saying we're not going to apply heightened scrutiny that usually applies to laws that discriminate on the basis of sex. Instead, we're going to apply rational basis review, and you don't have to prove anything. You can just, as long as we think that this is sort of rational speculation, and we're going to accept it. And that's a really, dangerous stance to have when it comes to, laws that discriminate on these grounds, because, one of the whole reasons why discrimination occurs is sometimes people pass laws not fully understanding, what it means to be trans. And you need to take a hard look to see if assumptions are really correct.
And in fact, the plaintiffs in this case did say that this should be granted heightened scrutiny, right? But Roberts just basically said no.
Yeah. He said we're gonna have an exception when it comes to medical conditions because
Right.
sometimes sometimes you do need to take someone's sex into account, like for a medical condition. I think there's some medical conditions that you're maybe at greater risk for if you're
Sure.
have one sex assigned at birth versus another sex assigned at birth. No one is saying that you can never take someone's sex assigned at birth into account when it comes to
Right.
medical treatment. All
Sure.
we're saying is that you need to have a good reason for doing it. And that should pass heightened scrutiny. And so, what our argument and what Justice Sotomayor argues forcefully in the dissent is that you got to apply the same standard that you apply to every other type of sex classification. And in fact, this is the first time in 50 years that the court has had a law that expressly, discriminates on the basis of sex, expressly says you can have this treatment if your sex assigned at birth is male but not female. It's the first time in 50 years that the court has not applied this heightened scrutiny to one of those laws. And that's a really bad sign when it comes to, how the court is going to respond to other types of discrimination. And right now, it's just an exception for medical care, which is bad enough. And we're gonna, work our hardest to make sure that exception stays narrow. But if you take it more broadly, that undermines sort of the foundation of equal rights on the basis of sex that the court has protected for 50 years.
Something I read, and I want to make sure that I have this right, is that in Roberts' decision, the court basically, the court did not rule on whether or not discrimination against trans people should receive heightened scrutiny, right? Like as an overall class. It's very narrowly tailored to this law. Am I right about that?
You're absolutely right. And I think that's really of critical importance that, both sides put in front of the court this question about what is the standard of review for laws that discriminate on the basis of that discriminate against transgender people. The other side argued that as a general matter, those laws just get rational basis review. And we argued as a general matter, they get heightened scrutiny. And so the court went out of its way to say, we're not going to answer that question, for other contexts. So, we're only focusing on this narrow medical context. And some of the justices who concurred, like Barrett and Alito, wanted to go further and wanted to say, we're going to say rational basis review for everything. And it's really significant that the majority didn't go there. So for all sorts of other discriminatory laws out there, the standard of scrutiny is still an open question at the Supreme Court. And lower courts, there are 4 different courts of appeals that apply heightened scrutiny to discrimination against trans folks. And in those circuits, they're going to continue applying heightened scrutiny. Those decisions have not been overruled. And that's just a really crucial point protecting folks.
You mentioned Amy Coney Barrett, and I have seen people saying that her concurring opinion is potentially scarier than the opinion that Chief Justice wrote for the majority. Is that why?
Possibly. Look, there's 2 routes to heightened scrutiny. And this is like, if you thought heightened scrutiny was sort of a technical thing, like I'm about to, the listeners can sort of, skip ahead, 3 seconds or something like that. One way is to say that trans people are sort of a discrete and insular minority that's a victim of discrimination and need extra protection. The other route is to say that what the Supreme Court has said when it comes to protection against firing people, that when you discriminate against someone for being trans, you're necessarily treating them differently than someone with a different sex designated at birth. So it's actually a form of sex discrimination. You're saying if your sex designated at birth was male, then you can't wear dresses. If your sex designated at birth was female, then you can. So it's like a very specific sex classification. So Justice Barrett's opinion says that trans folks don't get their own protection as a vulnerable minority. I don't see her decision as actually resolving whether it would be sex discrimination in other contexts. But
Okay.
it's still certainly discouraging. And I know that some folks have thought that she in some areas has been a more moderating voice than
Yeah.
some of the other justices. But I don't think this is one of those areas.
Right. So, okay, what does this mean overall? And obviously, first and foremost, what does it mean for trans folks in America? This particular case, I guess, only applies to this Tennessee law, but are there nationwide repercussions for this? As you pointed out, I think 25 states have categorical bans on gender affirming medical care. So obviously, this is not good for trans folks. How bad is it?
Yeah. Yeah. So these are bans for medical care for minors, first of all, which is an
Oh,
important,
sure. Sure.
it's
Yes.
important distinction because the next frontier are attempts to ban it for adults also. The immediate result is obviously horrifying and terrible. These laws were unthinkable 5 years ago. And now through half the country, trans minors can't get medical care that's really essential for them to, be living and thriving. And so I don't think you can just wash away the devastating impact of this.
Yeah.
And I think it's important for folks to, understand that. At the same time, there are still tools available to protect folks for the time being, and we don't want to comply in advance and read the Supreme Court decision as saying things that it doesn't actually say. So first of all, this is a law that only focuses on minors, not adults. Second of all, it's a law that is just focusing on constitutional equal protection claims. It says you have to treat everyone equally. It doesn't talk about claims involving, sort of a fundamental right for parents to provide medical care to their kids. It doesn't talk about other statutes like that prohibit sex discrimination in employment and in schools and in other contexts. And then it doesn't provide any support for the federal government to be doing anything because there is no federal law that prohibits gender affirming medical care for minors. So what we've seen is, the court in this case says it's up to the democratic process in these states to determine whether to ban gender affirming medical care for minors. But what President Trump has done is he, since the day he came into office, has tried to usurp the democratic process and try to ban this care unilaterally. And we've had to go to court to get injunctions to stop him. So if what Scrimeti says is that this is up to the democratic process, then that means that we got to follow the laws that Congress has passed and not what the president wants to just say in an executive order. And there's absolutely no federal law prohibiting medical care for transgender minors in any way. And it's important to remain super clear about that because they want to, make this illegal with just a stroke of the pen instead of actually getting Congress to pass something. And we're going to fight tooth and nail to, protect the ability of folks in states where this care is legal to continue getting it.
Well, Josh, thank you so much first for coming on the podcast, but also just for all the work you and the ACLU are doing on this. And, obviously we live in scary times right now for everyone, but trans people seem to have it particularly bad these days. And it's just an awful, awful situation. And I'm thankful that at least there are people like you out there and groups like the ACLU out there fighting the good fight. Thanks again for coming on and explaining all this to us. I really appreciate it.
Thanks for having me.